Welcome to another episode of Gentle Power.
Welcome back, everybody.
I think this is episode 30, which means we've been doing this for almost 8 months.
That's a good track record. We've put out a new episode every single episode.
That's
Excuse
amazing.
me. We've put out a new episode every single week.
Today we have with us Alex Daniels. I'm going to call you Alex Daniels and Alex Choi because there's too many Alexes in the room. This is one of my favorite episodes to record because, it's like free legal advice.
Yeah, pretty much. Until you ask me more questions.
Yeah. Try not to answer everything with, I'm not your lawyer and I don't know.
Yeah, should we just do one caveat up here that this is not legal advice?
And Alex Daniels
It's general
is not
legal information.
Legal information.
I like that. Yeah.
Alex Daniels is not your lawyer, our lawyer.
With that, I think we should also introduce Alex Daniels to our audience, who he is. So
I think he should probably introduce himself, but we can just introduce how we know him.
yeah, so Alex Daniels and I went to business school together. We were in the same class. Alex, we didn't really know each other until towards the end of Wharton.
Yeah, we became like venture fellows where we did backpacking trips. And
Yeah.
Oh, is,
So
is that the one you go to Patagonia?
we went on some camping trips.
Wow.
We were on the
Leadership
same
program.
team in the Appalachian Mountains. I remember that.
Yeah,
Wow.
we hiked 50 miles in the Appalachian Mountains together, slept under a tarp, and there were spiders crawling all over our faces.
And you paid for this.
Yeah.
We
By
paid a
going
lot
to
of money
business
to the
school.
MBA program. Yeah.
I got
But-
it. It was an opportunity. Yeah.
Well, so Alex Daniels was my Wharton MBA classmate, but he was also a dual degree with Penn Law. You are also getting your law degree.
Because one Ivy League degree was not enough.
No.
Yeah.
You just
No,
needed
I
to
wanted
collect them all.
Yeah.
I wanted all the letters. I'm going back for my MD next year, so I'm just kidding.
He's joking.
PhD.
I want to preface with you're one of our funniest friends. I think you should have your own Netflix special. You also deliver things with a straight face, so just want to let the audience know.
Yeah. So Alex Daniels has worked at Cooley, which is a renowned law firm in Silicon Valley, and they work with a lot of tech companies. You also used to work at Google, and you now have your own private practice, Decrypted Law, where you work with startups and founders. I guess I am now doing your intro.
Yeah.
Is there anything you want to add?
yeah.
Alex Daniels, I would love for you to do your own intro more thoroughly so people get to know you
I
better.
don't know. I feel like third-party intros are almost better because it's like that's what they see me as. But yeah, no, Alex nailed it. I mean, yeah. So I did the JD-MBA at Penn. Before that, I worked at Google too. So I have that tech. But I was on the business side, not law side.
What were you doing at Google?
I started in sales. I ended up moving to the finance team, and actually was not planning to go into law. But then I got the JD-MBA, and I started doing the JD stuff because it's easier to be a lawyer first and like jump to business than it's impossible to go from business into law. And then I started doing the work at Cooley with like startups and VC law, and I was like, oh, this is pretty interesting, and I like it. You help small businesses, startups get things going and not mess up and blow up their company. And then, as anyone who's worked with Big Law knows, Big Law is kind of a crazy business model. I kind of joke the only people who are happy with the Big Law business model are like the senior partners because they get paid a ton of money.
Yeah.
But associates are kind of miserable. Clients are kind of upset that they get like $10,000 bills in the mail for they don't know what. So yeah, I started a firm with a friend of mine who was also at Cooley at the same time. And business has been good because turns out if you don't scam people and you give them, not scam, if you don't rip people off and you give them good advice, they tend to be happy. And then
What?
yeah, I know. It's crazy. The business school, I can't believe I paid Wharton to figure that out. Actually, they didn't tell me that. That was just
You
kind of...
paid to go to the Appalachian with Alex, with Alex Choi to learn this.
Yeah, they didn't even teach me it. I feel like I was scammed twice,
You just keep getting duped.
Yeah.
Yeah.
Who are your clients now at your firm, just so we know?
Not the
The
specific
type,
people,
yeah,
but the
the
type
type
of
of
people.
client.
Yeah.
Tell us your entire book of business.
Open,
No.
yeah.
Yeah, let me give you all their social security numbers. And yeah, it's mostly startups. I'd say it's 80% we represent company, but we do a lot of like individual work. So it's a lot of people who are joining a startup, who are leaving a startup. There's a lot of that. And then we have a couple of VC clients who we just do their deals for them on the investor side of things.
Yeah.
But yeah, we kind of know the whole landscape because frankly, like we don't really care who we represent because it's all just knowing the law.
Yeah. The people joining startups, you said, or leaving startups, so you're helping with employment agreements, basically.
Yeah. Just letting them know what their rights are, trying to give them an idea of like what's market. Yeah, just helping them feel good. I mean, a lot of it's business decisions. Like if they're okay with the money or not. Like, that's not really our job to figure out, or if they're happy
Yeah.
with the severance. But yeah, just kinda
Yeah.
with that.
Yeah, and we have also just in our work and our clients, sometimes there are tricky legal things that
Yeah.
do come up as they are going through their negotiation. And so Alex Daniels is someone that every now and then we will ping. We try not to ping you too much,
Yeah.
but we thought, why don't we just have Alex Daniels on our podcast and we can get essentially
Yeah.
free legal advice?
And
Go-
it's so generous with us, with our clients, getting on some exploratory calls and all that. So we really enjoy partnering with you.
yeah.
Oh, thanks. Feelings mutual. You guys are very easy to work with, and everyone you referred has been really nice. And I don't know, I like doing this stuff too, so I don't mind talking about it. I mean, if you like call me at like 10 p.m. on a Friday, I'll be like, "What's going on here?" But
You're out clubbing, partying.
yeah, no, I'm like probably covered in poop or something because I'm potty training my kids. I don't know. Actually, 10 o'clock. No, they're asleep. I'm probably just watching Netflix or something. Who knows? Yeah.
So today there were a number of topics that we wanted to cover because these things have come up. And honestly, for us, we focus on the negotiations aspect and we have a perspective, but we thought it would be very useful for you to provide your legal perspective. Again, not legal advice, but this is legal information that may be helpful for people as they are going through navigating negotiations.
Yeah. So let's dive right in. I'm sure you're well aware, and our audience as well. It's an employer's market. It's a very tough market right now. Probably partially because of all the tech layoffs, and so there's a lot of supply and not as much demand, AI and all that. So we do observe that some people are looking for a job and they're okay with taking a job temporarily while they search more thoroughly for another one. We had a client recently who got an offer, is not super happy with it. We helped him negotiate, but it's still very far off from where he wants to be. And so he's like, I want to leave in about 6 months. And he was offered some sign-on bonuses, actually both first year and second year. He was saying, hey, I heard there's a law around the clawback clauses in tech where something like it's not enforceable anymore. Just for context for the audience, clawback clauses, at least what we've seen, is that you'll get a sign-on bonus. You have to stay for a year to keep it, but if you leave before the end of the year, you have to give it back or give it back proportionate to how long you've stayed. Can you speak to this? I did some quick search. It seems like something is going into effect. I didn't know how to read it from a legal perspective.
Yeah, I mean, it's the law, so that's been talked about for probably like a year now. They've been talking because that's how usually laws work. They it actually just got signed this week. I was googling in advance, like October 13th, so 2 days ago it became law. Important thing though is actually not effective for any agreements before January 1st, 2026. So if you've already signed an agreement like this, you're not out of luck or anything, but it doesn't
It's
apply.
not retroactive.
It's not retroactive. It's
Okay.
only agreements going forward.
Okay.
And it's really good. I mean, something you should keep in mind is California is a very employee favorable state because it's very much about like non-competes are illegal except in very narrow circumstances. And the idea is they want employees to be free to move around, work for other employers, not get like trapped in a job because there's, like a signing bonus that they have to pay back, with certain terms or something like that. And this new law doesn't like ban signing on bonuses. It doesn't ban any of these things, but it just makes clearer rules that if you're going to make it enforceable, then it has to be like a standalone agreement and there can't be interest on it. And if the person's involuntarily terminated, so they're fired, you can't force them to pay back the sign-on bonus. It's if they leave. So it's just a lot more protective.
Yeah.
It also puts a cap. I think it's like they can only be up to 2 years you earn it. So you can't have like a sign-on bonus. If you like leave within the first 5 years, you owe all our money back or something.
I see.
So it's just a lot more like reasonable, I would say.
Yeah. So just to make it very explicit, there can still be clawback clauses. They can still ask to claw it back. It's just more reasonable now.
Yeah, for sign-on bonuses, but they've banned certain types. Good examples like relocation fees. Like if a company makes you move and they give you like $5,000 or they pay for the moving and you decide, oh, I want to leave this company, they can't force you to pay it back unless, there's narrow circumstances. The law is like pretty well written. I mean, California's pretty good at writing laws where they get the caveats down, and I'm sure it'll be amended over time. So a lot of these rules still are in place, but now there's just more like guardrails on it, I think is a good way to put it. A lot of these like clawback provisions.
And this clawback clause law that you said that was signed 2 days ago, that is only here in California.
Yeah, yeah.
And so this is state level law, and there may be other states that have similar ones, but
yeah. Do you know if it applies in other states, New York?
No, but like it's one of those things where I mean, California is the biggest state population wise, so that's a huge thing. But it's called the California effect. Typically, whatever California does, like other states follow.
Yeah.
So I wouldn't be surprised if states like Colorado, Washington,
Massachusetts, yeah.
Massachusetts followed. If they might actually already have stuff like that, I'm not aware of it. So it's good, and I mean, for in California again, because what is it like, 5 to 10% of Americans, 10% of Americans live in this state. That's a big chunk of the U.S. is covered.
And to get a bit more detailed on it, is it that the company needs to be based in California, or the employee. Or both, or
the employee? So it needs to be a California located role.
Yeah, and this is a general rule for employment law that I think a lot of people should keep in mind is like as a matter of public policy, if your company is based in, I don't know, Arkansas, whatever, but you are working, living in California, California law is going to apply to your situation because California's mindset is like, you're in our jurisdiction, you're a California person, our laws apply. Even if your agreement says we agree to some other state law, like typically California law will just, the judge will throw it out and be like, no, we're going to apply California law. And same for any state. Almost every state would do that.
What about if a company is based in California, that's where it's HQ'd, and I am an employee, a remote employee that lives in another state?
Then typically, that employee, wherever you live is where your employment law typically is established. Yeah.
I see. Got it. So just to recap on this clawback clause, this law that was signed in California a few days ago, it essentially puts in more guardrails or constraints on the employer side so that they can't game it.
More employee friendly.
Way more.
And it goes into effect, I assume, January 1st or something like that.
Yeah, this year, January 1st, 2026. So any agreement signed that day or after, which is most of them going forward, is going to be there, assuming that we still have a country, I think we will, knock on wood. But it's really good because, again, it does. So I would say a good way to summarize it is it bans certain common, like, retention, kind of aggressive retention things, like moving expenses being repaid, or like visa costs are another really big one, where, like, if you have a foreign person moving here, you don't repay that just if you leave if they've already covered you. So you can't do that. And then for sign-on bonuses and those kinds of things, there are just restrictions on how they can be repaid. So it's not like the company can make a super favorable sign-on bonus structure that kind of traps the employee there. Otherwise, they're on the hook for like tons of money.
Yeah.
The question that our client was most curious about also was, even if I have a clawback clause in my offer letter, if I find myself in a situation where they're trying to force me to pay it back, it's not necessarily enforceable. Is that true, or is it case by case?
Well, if it already was signed, then that one's enforceable in California. It's only for future agreements. But, I think it also is a practical matter, and this isn't, like, again, not legal advice, but it depends on how much the money is. Like, if they're trying to claw back, like, they gave you $5,000 for moving expenses, 6 months ago or a year ago, and they want it back, I mean, what are they realistically going to do? They're going to, like, take you to court over, I mean, it would cost them, like, as much money to get it back, and it would look really bad on their part, right? So you kind of always have to weigh, like, the practical risk is, like, yes, you can do things that are, like, violate the contract. They're not illegal, I mean, within reason. And it's just the kind of thing where, like, are they really going to come after you for a civil claim for this amount of money?
Yeah.
Most companies don't because it's not worth it. Now, if it's like a $100,000 signing bonus, you sign on and you leave after 2 days, they're probably going to be like, give us our money back.
Yes.
But balancing act.
Yeah. Thank you. That's very helpful. So this actually reminded me of, we've worked with hundreds of clients, and usually there's consistent terminology, sign-on bonus, base salary, and all that. But sometimes we see terminology like retention bonus, and then there's some small difference in it where they pay it to you at the end of the second year of employment. and things like that. Do you have any general thoughts on companies naming things differently with just a few little tweaks?
I would say the name, I'm not, they can call it whatever they want. Like, whatever. Like, it's just a word, right? It's like whatever it actually says. I mean, the real difference is like a sign-on bonus. Sign-on is like you get the money up front.
Yeah.
Retention is you get the money on the back
Yeah.
end, right? But they're very similar. And yeah, I don't know, whatever they call it, like, it doesn't really matter. It's just because they functionally all fall into like the same Sorry, you can call it like 5 different things, but they're going to do the same thing. So it's like, walks like a duck, talks like a duck.
Yeah.
It's a duck. Right?
Okay. With the retention bonus, there's no clawback because it's already given after you stay. So
Yeah. I mean, if you earn it, it's yours.
yeah, you earned it. Cool. Do you want to?
Yeah. So the reason why our client had that question about, well, if they're trying to claw it back, is it really enforceable? I think our client was thinking about the clawback clause falling in the same bucket of, let's say, NDAs or non-competes. And I don't know if this is just a common myth or if it's actually real, but we often hear, hey, even if you sign an NDA or a non-compete, at least in the state of California, it's not truly enforceable. How should we be thinking about this?
Oh, yeah, it's super easy in California. Non-competes are not enforceable. And in fact, if they have it in the agreement, it's illegal. Like, they can't even... You have a cause of action. You could like report them to I forgot what it's called, not the Department of Labor, the Industrial Relations, they call it in California or whatever. Like, that's not even allowed. Non-competes are only legal in California in like one very narrow circumstance, and that's like where someone acquires someone else's business, and it's a business that you just don't want them to compete in the same area as you, which makes sense because like I bought your business, I don't want you to like just create a duplicate next door. But no, it's very easy. And non-solicit solicitation, so like talking to a customer's employee, is also not legal in California. You can't restrict the flow of communication and people in California. So I know California gets a rep for being like super like, I don't know, like communist or whatever, but it's actually like a lot freer in a lot of ways for employees. Whereas you have other states like, a Texas or a Florida, their non-competes are just, they're kind of the standard there. Like, they're just expected.
Wow. Yeah.
And what about NDAs?
Yeah, I mean, depends on what the NDA says. Those are binding because those are contractual agreements. So those are totally legal within a reasonable time frame. If you're thinking of like confidentiality, then there's nothing. California is pretty much like every other state. They want companies to be able to protect their information.
That's interesting because I thought, in startup land, you hear a lot about NDAs and how like it's kind of poor form especially for a founder to ask a potential investor or anyone else just looking at their deck, like, oh, here, sign an NDA. And my impression was that, I mean, at the end of the day, a business is so much more about execution than just the idea.
Yeah.
But I thought, is there any sort of like, well, I assume it's also hard to track down who said what to whom. Like, how are you going to hold them to it? But you're saying that they are still, enforceable if you can trace it back?
Yeah, I guess. Well, I guess when we're talking about NDAs, it's like they're legal if they're used for legal purposes, like protecting company information, like trade secrets, like even a deck, whatever. I mean, whatever. I know it's ideas. They're not legal if they're used to like, what's the right word here? Like silence someone. Like the NDA is like you can't talk to anyone. That's not cool. Like there has to be a valid purpose behind it, right? But that's true in almost every state. So NDAs aren't really like different in California. I mean, they're a little bit, but as long as it's like a valid use of an NDA, then it's not really a problem.
Okay, got
But
it.
non-compete's the big one. I feel like a lot of people don't. Everyone hears they're not legal, but they don't realize like the extent that they're not legal. Like
Right.
they're just not allowed.
I didn't know you couldn't even have it as a company. You can't have it in the employment agreement.
Yeah.
And again, just so I understand, in this case with the non-compete, it's if the company is based out of California, not if you as the employee are in California, right? Or both?
Yeah. If you're a California employee, again, employment law, all this stuff is about the employee and where they're based.
Okay.
Right.
So if you're a company founded and based in Texas, but I live in California, if you're hiring me and you send me an employment agreement and it has a non-compete, I'm like, I'm going to report you to the industrial affairs.
Yeah. No, it's the same thing. I mean, I guess a good way to think of it is wherever the company's based doesn't really matter because the relationship with the employee is in the state that the employee is in. Right. It's like, I don't know. I mean, that's if I'm working for some company in Azerbaijan or whatever,
Yeah.
it doesn't matter. I'm subject to California laws. I'm a California employee, and California will apply its own laws to me because why do they care what Azerbaijan should? Like, I'm using the resources. I'm in California.
Yeah, I
So,
see.
the headquarters don't really matter that much. Like, for example, Google's based in California, but I'm sure it has Texas employees that
Right.
it's using Texas law for because it can. It's not
Yeah.
like it carries over. I mean, if it was smart, it would probably do it.
Yeah. And again, if someone is remote, it's still wherever they're based out of that matters.
Yeah, it's wherever you work and reside. That's the
And
big
what
one.
if you're nomadic?
Well, it would be like typically you would like establish a state of residence. That'd be that. I mean, that gets a little funky. I don't know. Like if you spend like a week in every state in the U.S. or something in a year, you might have some weirder problems. Then by then you might just use whatever state you spent the most time in, or whatever. I'm not gonna go edge cases. It's
I
crazy.
see. Okay, never mind.
So just to summarize, with the clawback clause for the state of California starting January 1st, 2026 and on, there are now a bit more protections or constraints on an employer, there are more protections for an employee. It's a law that is a bit more employee friendly. So, but still, even if whatever is basically in your offer letter, just assume that that is enforceable, but there have been now more protections in place for the job seeker. And
Sign on
then,
to January 1st, you have a lot more protections if it's something specifically that's banned, which is like relocation costs being repaid, that's banned. Or if it's something like visa costs being repaid, that's banned. And if it's something like a sign-on or retention bonus, that kind of thing, or more sign-on bonus, actually not retention bonus, then there just has to be specific rules about that.
Yeah.
got it. And then for non-competes in the state of California, they are basically not allowed except for that very specific
Yeah, you
case.
gotta buy someone and make them not compete.
Got it. And then NDAs are not really enforceable unless it's to protect.
No, they are.
Oh,
Like,
they are. Okay.
legit NDAs. Like, so if the real purpose of an NDA is don't disclose confidential information I give you.
Yeah.
Right? That's totally legal. That's just a contract.
Yeah.
Okay.
It's not illegal. What's not legal is if I give you an NDA for an illegal purpose, it's like, oh, this is called an NDA, but it's really not just about protecting my confidential information. It's like you also can't compete with
Silence
me.
you.
That's a non-compete.
Got
Right?
it.
So it goes back to like whatever you call it doesn't really matter. It's what
Right.
does it actually do and say.
Yeah.
Yeah.
The spirit of the law.
Yeah.
Yeah.
I think the biggest takeaway I'm getting here is just read whatever you're about to sign before you
Yeah.
sign it.
Yeah, or get a lawyer to read it, or
Yeah.
or honestly, I always tell people. By the way, ChatGPT, Gemini, awesome. I use them all the time for stuff. It's like great for not like legal work necessarily. Like, definitely not any confidential. And everyone should be really careful about what they put in there because obviously, it's just they're building a database out there. But it's really helpful too. That can give you like an initial read on stuff too. It's gonna say a lot of crazy stuff. I
Yeah.
guarantee it, but there'll be some good nuggets in there. So that's
Yeah.
like a nice starting point.
We made a podcast episode on how AI, when it's useful for negotiations and when it's actually dangerous. So
Yeah, it's kind of crazy. I don't know.
Yeah.
I was using it today for something, and I was just like, "What is it smoking?" Like, I was like this, like went on a rant about something, and I was like, "What are you talking about?"
yeah, why are you ranting to me? Yeah.
It was like if I didn't know that it was going on a rant, I would like follow, and I didn't know what I was doing. I'd follow it down that rabbit hole and be like, "Oh, I figured this out." And I was like, "This is insane. This has nothing."
Okay.
Anyway, moving on.
No, for me-
kind of scares me a little bit. Yeah.
Yeah. For me, it's how extremely bad at math it is, even like very
really?
simple math. Yeah. I just like how many days are in between this and this day. It's like obviously bad. Things like that. Okay, moving on to the next question. So we have a lot of clients who are either negotiating severance packages or they are thinking proactively because of all the layoffs. So a couple questions on severance. Do people have any leverage at all, or is it just be nice to them and ask? Well, I guess, maybe there are some edge cases that we have talked about previously together, like, pregnancy, any protected class and all that. I would love to hear in general, like the average person and then protected classes. How do you recommend people handle severances? What is negotiable, if anything? And then can you negotiate termination or severance terms at the beginning of your employment?
Yeah, definitely a lot there. I would say I always advise people when it comes to severance. I typically, and it's not like a law, but like a general rule, typically like 2 years to a year is how I would measure it. So you've been at a company 4 years, you should expect to get at least 8 weeks severance. You know, if you've been there a year or less, anything over a couple weeks, that's just like kind of a barometer of like how reasonable your
Like
severance is.
2 weeks per year,
Per
roughly.
year you were there. That's
So you
just
were
like a
there.
good starting point. So if you're like, oh, I got a month, like, is that good or not? I was like, I don't know, how long were you there? If you were there like 2 months, that's awesome. If you were there
Yeah,
like
that's true.
10 years, you probably get better. You should probably get more. It's not perfect, obviously. And the leverage piece, yeah, I mean, generally the two times you have the most leverage are when you're getting hired and when you're getting fired from a company or you're whatever leaving. But the how much leverage you have was really going to depend on so many factors. We talked about protected classes. That's a huge one.
For
Like,
sure.
and I'm not trying to be racial or anything, but if you're like a person of color or you're, female or just a protected class, there's so many in California. I mean, they have ones for like genetics. They have ones for like hair in a racial sense, like
Wow.
hairstyle.
Yeah.
California is very good at protecting employees. If you have those protected classes and you have reasonable grounds to believe that you may have been treated differently, implicitly or expressly, whatever, like, then yeah, you have a ton of leverage.
Okay.
Because just imagine, I always tell people, imagine if you were, I'm just gonna use two
Yeah.
protected classes, a
Yeah.
black female, right?
Yeah.
And you go to a jury. Who are the people, the jury, like you and me, gonna side with? Oh, this multi-million-dollar company or billion-dollar company, or like this person who's an individual who has reasonable grounds to say they were mistreated.
Yeah.
So companies will typically give you more if you have that kind of leverage. And also if you've been at the company a long time, you were in a senior role, those aren't protected classes, but like if you were the COO for 5 years, like where the bodies are. Like they're gonna want you to like sign a release. Whereas if you were just like some analyst at the bottom of the totem pole and you're there for like 6 months, they don't really care if you don't sign the release. You're not
Yeah.
gonna do anything to them.
So, in what sort of layoff situation do you think someone has more leverage? So, protected class, I remember we were once talking about how if you are part of a mass layoff, so there's
Yeah.
a large group of people who are being laid off, you probably don't have much leverage because it's not like you were individually singled out to be let go. But then maybe if in that case, you probably have less leverage than maybe if you were just laid off one off, no one else is being laid off. In that scenario, do you have a bit more leverage, or how should one think about this?
Yeah. If you're so mass layoff, like a RIF, a reduction in force, is what it's called. Those are typically done for like cost reasons, is the excuse. They'll be like, we chose people or whatever. It's yeah. Typically, if you are a one-off layoff, you're going to have more leverage because you just have more circumstances to be like, why was I the only one? You know.
Right.
Whereas if you're, going back to like the black female example, not picking on black females or anything, but and if you're like one of 100 people who got laid off, it's hard for them to be like, well, we discriminated against black women because we also laid off like all these other different protected classes and non-protected classes and stuff. So yeah, it really all depends. But I mean, I always tell people like, what does it hurt? Like, just try and negotiate. Like, if it doesn't work out, you have the original offer. I don't know why they would take it away from you because it gives them benefit. And yeah, squeaky wheel gets the grease. If you don't try
I
and
agree.
squeak, like no one's gonna give you that extra money. So.
Yeah. And so would it help for someone in that position? They're facing a layoff and they're negotiating a severance package. Like, should they work with you, or like what do you recommend? They just ask for more? That's it? Like what's
Yeah, I mean, it depends. So, there's two things. So, I'm a corporate attorney. You could definitely work with a corporate attorney to help you like negotiate things, stuff like that. If you actually want to do litigation, like you feel like you were wrongfully terminated and you have like a legit claim, like I was fired because I was a black woman or something, whatever, or I was sexually harassed and I was retaliation, why I was terminated, then you get an employment litigator. The downside there, which everyone should be aware of, is like employment litigation is a contingency fee basis. So they will take typically like 30 to 40% around there of whatever you get.
yeah.
So it's not really worth it unless you're like looking for a much bigger payday, right? Like if it's like, oh, I get 1 month severance, let me hire a litigator, get me to 2 month severance. It's like you basically you came out where you were before,
Yeah,
right?
yeah.
So yeah, I don't know. I
I
hate to be the
see.
lawyer, but like it depends on what you want to do. I would say try to do it yourself at first,
Yeah.
or talk to a lawyer to get some tips, review things, make sure you're not giving things away.
Yeah.
But then for the most part, you should just DIY it as long as you can until you actually
Yeah.
want to like get serious.
Yeah. We had a client who it was such an unfortunate situation. She was part of a mass layoff and she had been there almost a year, like literally 2 weeks away from her 1 year mark. And her equity, which was it was a public company. So the equity was pretty liquid. It had a 1 year cliff. So she couldn't do anything up. I mean, she couldn't do
Was it an
anything really.
option or what was it? Do you know
No,
kind
like
of
a straight
No.
up
what she did
RSUs.
stop?
Yeah.
Oh, RSUs. Okay.
And I remember in her case, when she first signed the offer, her salary versus equity was on a sliding scale that she could choose. And so she chose the lower cash comp and higher equity
Yeah.
because she really put a lot of value into
Yeah.
that. And then she was laid off just
We
a few
weren't
weeks.
working together for that. Yeah.
Yeah.
That's unfortunate. Do you is there anything she could have done? I guess.
Not really. I mean, because it is a contractual thing. It's just that's why. I mean, honestly, we always tell people. My advice typically for clients who are like prioritize more. I always tell them go more for cash, because if you're killing it, you can always get more stock. But
Exactly.
yeah, I mean, the whole point of getting stock is that it becomes cash. So like,
Right.
why don't you cut out the middleman? Just take the cash now
Agree.
and do things with it. Like I don't know, go buy Disney stock or something, whatever you want. Like you know, if you really love stock. Yeah. No, that's one of those unfortunate things. There are concepts in contract law like detrimental reliance and stuff like that. Like if she was promised stuff and she like stayed longer, but it's kind of a stretch.
Yeah. Yeah.
Yeah. And there was another question Gerta had was, what are your thoughts on someone negotiating severance or their termination terms when they're accepting the job offer at the beginning?
Yeah, it's unusual. It happens. Some of our I won't say smarter, but some of our more like cautious clients actually have that in their offer letters. They'll preemptively give you like, here's the severance you will get if you're fired, before this date or whatever. It's tough because again, it goes back to like you don't know what it depends so much on so many factors at the time of termination. Like what were the circumstances? Like do you feel like you have a claim? Like for example, like if you have like a sexual harassment claim or something like that, like you don't preemptively know you're going to get sexually harassed before you join a company or something, right? Like, well, and if you do, like maybe you shouldn't join the company. So yeah, I mean, you can do it. I think a lot of employers are going to be like, let's not worry about that. And you also, I mean, keep in mind, like, it's a relationship thing. You don't want the
Right.
employer to start being like, oh, this person expects, like, disputes and stuff like that. But
Yeah.
I would say if the company brings it, it's worth talking about it.
Yeah, we have seen this more with some of our more senior clients because they tend to have a bit more complex offer letters and terms and clauses. So yeah, I guess it is a balance between getting things locked in for clarity in the future versus balancing that with the relationship and maybe not raising signals and alarms and seeing how much how important it is for you compared against the relationship.
Yeah.
Yeah.
Alex, I want to be mindful of your time. Can you go to 3:30 by any chance?
Yeah, I know. I'm just,
Okay.
we got emails. I'm an email manager. Yeah.
Okay, so let's move on to the next question. So this is on pregnancy. We get this a lot for some reason. We get a lot of clients who are pregnant. So I'm curious, what are your thoughts on how to handle this with employers? When to disclose? We tell people ideally after you get a written offer. Is your opinion like after they sign? Like is it best after they sign? I assume it is best, but you want to balance that with like, I guess the social capital as well. Let's talk about that first and then.
Yeah, I mean, so if you have an offer and you're pregnant, so I mean, legally in California, I'll just talk about California, they can't not hire you because you're pregnant. That's just the law. But as a practical reality, how are you going to prove it? Like, unless they have an email, you say, I'm pregnant, and be like, well, go to hell. We don't want pregnant ladies here.
Right.
Like, we'll never hire you. They'll just find another reason. They'll just be like, oh, it wasn't a good fit. Or they'll find another candidate, especially if it's like a more employer-friendly market like it is now.
Yeah.
So, yeah, I tell people, like, well, no need to disclose it unless there is, like, some real pressing need. Like, in California, and it's a federal law, too, the FMLA. But the only reason they can discriminate on it is if, like, the job needs to know. Like, if you're handling toxic waste, you can't be pregnant because you're going to kill the baby, or you can't lift heavy things if you're pregnant.
Right.
So that's the only time they can do it. So I'd say that. And then in terms of disclosing it, I tell people, like, if you have the job already, you should tell them once you're comfortable doing so. like there isn't really a downside. The downside is that there's social capital lost or whatever, but that technically is going to happen anyway, and it's not even legal. But it kind of it establishes your protected class status sooner.
Yeah.
So, you don't have to say like after you're 2 weeks pregnant, maybe after the first trimester, if you're like, oh, this is happening and people are going to notice. And I want to tell people, just tell people like, just get it out there.
For sure. But I guess we were referring more to when you're in the job offer process. So a lot of clients, they want to tell as soon as possible. I typically tell them, ideally you tell them after you sign so that you're more protected. They can't take away the offer. Now it's more obvious why they're taking it away. But then I guess second best, a compromise between social capital and negotiations and all that. Maybe after you get the offer, at least the verbal offer. What's your take?
Actually, I agree with you. That's what I was saying. Like legally, they can't fire you. So you can tell them whenever you want, and they legally. Right. But I would wait until you're signed and you're done. Not even verbal. I don't really. Verbal's binding as much as written. But how can you prove oral? Someone would be like, "Oh, I just promised. I was considering it. I didn't say definitively you have the job." Yeah. So I would wait until afterward for that because
after you sign.
A lot of jerk. I mean, a lot of employers are out there who don't care, and they will just fire you or not give you the offer.
Agree.
Yeah, we had a client who was in this situation, and
share the case study.
Yeah, and a pretty big consideration, I'm thinking of another situation. Okay. So we had a client who had this situation, and she was really grappling over when should I tell the employer, and the social capital piece was a really important part for her, and so we had to think through how do we want to balance when we notify them in a way that will protect the offer and that you're locked in and the company can't retaliate against you. But she was really worried that, will the hiring manager think that I was hiding this and I was being deceptive by not sharing? And so we did a lot of work with her on how to very tactfully communicate that in a way where you reduce any risk to the social capital, as well as notifying at a time when it actually made a lot of sense for her in the process where it protects her offer. And ultimately at the end, I remember the response from the recruiter was a pretty canned response that was like, congratulations on your thing. Here is how our maternity leave works. And they basically just implemented the process for the maternity leave info, right? So it turned out not to be as scary as we thought that it would be.
Smart companies have good lawyers, and they're also not jerks. Like they'll get if you say they're pregnant, they might be like a little bummed. They're like, okay, well, she's on maternity leave for 6 months, but you're pregnant. Like it's good for the world. Like it's good for you. I don't know. It's like it's also a real medical condition. Like anyone who had, when my wife's had pregnant, like if you haven't seen a pregnant person up close, it's like being disabled for the entire time. Like you have a lot going on. Yeah. So I think most people recognize that. And the nice thing is there's a lot more women in power now in positions of leadership who've been pregnant and appreciate it. So it's not just like some white guy who's like, well, my wife did it in 1940. You can do it now.
And
so I just wouldn't be as nervous saying, but I would say do it after the offer because then you're locked in, you're protected. Before the offer, you are technically protected, but you don't have any legitimate leverage because they can just pull the offer for a million legitimate, other excuses that you can't prove otherwise.
Mm-hmm. Yeah. I want to get your thoughts on this quick case study because it was so interesting how they maneuvered out of it. And I sometimes I look at these negotiations like, oh, that's brilliant, that move. Like, very creative, also kind of evil, but basically
creative and evil.
So we had a past client. She was supposed to move to, so let's just make up some cities because it's easier. So let's say, I think she was based in Minneapolis, thank you. And then she was applying to move to, let's say, Boston. And so she was pregnant, and she told them after she signed. The offer came in at Boston levels because they wanted her to move. But then she says, hey, I'm pregnant, and it's a difficult pregnancy. So because of health reasons, I can't move to Boston anytime soon. I have to stay in Minneapolis for several months, and probably during the mat leave and everything. So she would have to move much, much later. So what they did is, even though she had signed the offer, they changed her offer letter to now be based out of Minneapolis.
Yeah, makes sense.
Okay, so this is fine.
That makes sense. It goes back to the governing law. It should.
But sorry, what the point that we care the most about is that they reduce the compensation.
Yeah, I mean that's part of
Yeah.
it because I'm sure that they have like tiers, like it's a lower cost of living or whatever.
Yeah.
I think it's as long as they're following like a non-discriminatory blueprint based on like objective factors, like housing costs are way more in Boston than they are in Minneapolis or
Yeah.
whatever. I
Yeah.
think Boston's like the second most expensive city in the U.S. now, or whatever.
Really? Wow. After New
It's
York?
up there. It's like up. Well, it's probably like San Francisco, Manhattan, and like Boston are up top three. I would assume.
Yeah. I'm
Um,
not surprised at all. Yeah.
yeah, but I mean that's totally fair they do. And I was saying it goes back to the fact that the governing law is where they reside. So if the person's going to be living, residing, working out of Minnesota for a year
Yeah.
plus, paternity leave and stuff, then the thought is like, yeah, we're going to make you a Minnesota employee. If you want to move to Boston after you're done with that, you can do that. We'll make you a Massachusetts employee. But that's totally in their
This
discretion.
is fine. You're saying this is fine. Okay.
Yeah,
I
that's
thought
legal. I'm
it.
assuming the company did its diligence. They probably just have like a straight tier system where they're
Yeah.
like tier one high cost of living cities. Get this? I have it with my wife works at Microsoft and we live in
Yeah.
San Diego, which is not high cost of living. Whereas like Seattle and San Francisco are, we're
Yeah.
like that's very high. We're just high or something. So that's totally valid because it's not discriminatory. It's just based on like
Okay.
economic numbers.
But they could have also just kept a Boston offer, right? Like, because
Yeah, but I totally get where they're coming from. They're like,
yeah,
you're not even gonna be working in Boston.
for a
You're not in
while.
Boston. Why are we paying you like you're in Boston?
That's a good point. Yeah.
Yeah.
I
I
I
don't know.
found it. Yeah. I found it a bit because she had already signed and everything, and
Yeah,
it
I
was.
think yeah.
It's also a health thing. Like, it's not like she's like, actually, I want to move later.
Yeah, but I mean, if she had this, it's a catch-22 because she could have also disclosed it up front, and I think there, I would assume. I mean, the company is also reasonable. They could have been like, no, you have to be in Boston. Like, you can't take this job. You're
Wouldn't
fired.
they? I mean, they have to accommodate her because this is like a disability, you said, and pregnancy.
Yeah, but like they could have been like, after you have the kid, you have to come here as soon as possible. Like they could have rescinded the offer. That's fine.
They
Everybody
could.
could have been
They
sued on
could.
that. But I would say another thing to consider is like
Wait, sorry, Alex. Did you say they could have rescinded the offer?
they could do whatever they want, and I
But
think
isn't that like a protected class?
no,
Like,
because remember what I said? You can discriminate on pregnancy if the pregnancy affects the ability. So I use like toxic waste and lifting heavy stuff.
Yeah,
Like
yeah,
you can't be pregnant to do that. But if the role was like, hey, you need to be in the office
no,
five
but
days
this
a
is a
week.
tech
Oh no, I
role.
know. I'm just explaining. Like if it was a job that's like, hey, everyone's in the office in Boston. You told us you could move here. After the fact, you told us you couldn't move. Like I don't really care what your excuse is. Like you can't do this job. It's not because of pregnancy. It's because you are unable to do a core thing we told you. Again, it's a tech job, so it's fine. But I'm actually on the company side on that because
Okay.
why should they pay extra if the person's not using that for living
Yeah.
expenses?
No, the extra, I get it for sure. I get that. I don't agree with. So some companies just need you in the office for no good reason. Like it's just a laptop job. Do you
Yeah.
think if the company had a be in the office, I don't know, X days a week policy, and then she's like, I can't move because I have this disability, which is in this case pregnancy, and then could they have rescinded it and be fine?
So I think the distinction there is if she had signed, if the offer letter had said, "Hey, we want everyone in the office 5 days a week, 4 days a week, whatever," it's really important for team morale. That's just a condition of employment here,
Yeah.
and she signed on to it. And then she said, "By the way, I didn't disclose this, but I have a medical condition and I can't comply with this thing you told me I have to do." I think it'd be fair for the company to be like, "Okay, well, you knew this was a condition. Now it'd be different if she signed on the offer." And then 6 months in, they're like, everyone has to be in the office now 5 days a week. And she's like, oh, I have a medical condition. I can't go. Then they can't just fire her for that because they
Right.
haven't accommodated. Like if they can reasonably accommodate her. So in
Right.
that case, they would be fine.
What about, let's say they already have the policy, some woman signs, and then she gets pregnant and has a difficult pregnancy that doesn't allow her to go in person. Do they have to accommodate that?
Yeah, it's a disability. It's the same.
Okay.
If they can reasonably accommodate it, so if it's a tech job, for sure.
Yeah.
Like if it's something else like
I
in-person teaching, right?
Yeah,
And it's
yeah,
like, oh, I can't go into the building. I mean, they would still probably accommodate it somehow.
Right,
They do
right.
like virtual or something, give her some other job.
yeah.
Then no. Or it was like a construction job, right? Like it's like no,
Right.
you have to like be here to like put the things together.
I guess it's a little frustrating on my end as a woman because if let's say the company has the same policy, let's say 4 or 5 days a week in the office, You join, you get pregnant during, it's a difficult pregnancy. Now they have to accommodate you. You can work from home and, I don't know, move to Minnesota with your parents or something. But if you're at the offer stage, they choose not to accommodate you, right? They can
Well,
choose.
there's nothing to accommodate yet because you're not working there. And
Well, after you sign and you're like, I'm pregnant, it's a difficult
yeah,
pregnancy.
because I think the difference there is they told you what the conditions were going in,
Yeah.
and you said, yeah, I can meet these, and then you sign the letter, and then the next day you're like, actually, I couldn't meet those conditions because I have a medical condition.
Yeah, no, I
Well,
get the logic, but it's like the
yeah.
fact that they can accommodate if they want to, but they choose not to up front. It's a little frustrating, especially since maybe for me, it's also I resist the idea that you have to be in office 4 or 5 days a week.
Yeah, I mean, I agree with you. I hate
Yeah,
it. I mean, when I found my own thing, I did not want to go back to Palo Alto, California.
same.
I'd go crazy.
Yeah, yeah, yeah. Okay, well, thank you for your perspective on
Yeah.
that.
By the way, it's not about like the pregnancy or not, but you have to realize it's like more on did you know you could do the role going into it or not?
Right,
And if
right,
you disclosed in the offer, like, okay, hey, I can do that, but which sounds like your person did, but like, hey, just so you know, like, I have a disability and that I'm
right.
pregnant and I need paternity leave, and they're like, okay, but I'm sure that if that policy was there, I'm seeing the company's agreement was like, okay, well then in 2 years, if you're still at the company, we expect you to move to Boston.
Right, right.
You know,
Yeah,
that's probably what would happen and would have gone
yeah.
down. Like,
Very quick tangent is we went to Burning Man this year, and I don't know if you heard, huh?
no, no, I didn't someone like get murdered there or something?
Someone did get
What?
murdered.
I didn't hear anything more about
But
that.
yes,
Yeah.
we don't know what happened. But they also
I don't know.
someone gave birth and didn't know they were pregnant. Did you hear this? As I
That's disappointing in society. I was like, how do you not? Were they like really?
I don't know.
Maybe it was an early birth or so. Who knows, right?
Yeah, but what I was the reason I was reminded of this is that our client could have technically said, "Oh, I didn't know I was pregnant."
Yeah. I mean, yeah. And, also, again, like I say, most companies aren't like dumb enough to like fire, rescind offers based on pregnancy. But it's just the context of like how was it communicated? What were the requirements before? What did they understand? That's what I'm saying.
Yeah, for sure. I get it. You wanted
Okay,
to-
so next topic. We're almost here towards the end. I know we've been
It's
been
so
sucking
fun.
you dry
No,
of
but it's
these
Fun, huh?
legal.
it's fun
Yeah.
chatting with you because it's also funny. I see.
Yeah.
The least dry lawyer that we know.
Thanks, guys. That's like saying like the sharpest spoon. That's like, yeah, I did it.
All right, so equity. We have a lot of
Oh,
clients, a lot of people who are applying to startups and of varying stages, all the way from pre-seed to series A, B, C plus. And what are some important things for them to keep in mind around their equity package?
Yeah, I mean, well, this is one where definitely talk to a professional because equity, there's so much, your tax professional, attorney, professional negotiators like you guys, like anything like that, because this is where, again, there's just like people write books on this stuff. I would say that I break it into two ways. If you're early stage, sorry, let me backtrack. Overall, I kind of mentioned it before. I always recommend people just try and get as much like cash bonus as they can versus equity, because equity is great, but its expected value is zero for most startups. And unless you know that they're like an IPO, and even then, if you know they're going to IPO, it's going to be like a year before it actually happens. You can sell, and you have lockups, so you have like to hold it for 6 months afterwards. So equity is like not that valuable in a startup. And just think of it as like if you have 1% of Google at the Series Seed stage, or you had 0.5 at the Series Seed stage, either case you're like on a yacht somewhere right now, right? Like so the gradations between like 0.5 and 1% are meaningful, but like they're not like control of the company, and you're still gonna get paid out. So early stage, I would say what you should really push for as much as you can is restricted stock awards, which are RSAs, not RSUs. They're horribly named. I don't know why they're so similar because they're actually like inverses of each other. Restricted stock is kind of like founder stock. It's just straight stock. You get it. If you've heard of this thing called an 83B election, you file that.
Yes.
If you can't do that, then I would push for options, but it's called an incentive stock option, ISOs, and try and have them be early exercise, which means that you can choose to exercise them before they're vested. And if you leave before they vested, the company just buys the stock back from you. My point is like, if you have any kind of deferred compensation, like options, restricted stock units, right? Those are things where like you own the right to buy stock, but you don't own the stock. So early stage, try and get the stock. Like try and structure your equity in a way that you're getting stock. So it's RSAs or incentive stock options with early. If you're later stage, I would say like Series C, D, E, whatever, or like later stage company, then I don't know, get what you can. I don't know. Like RSUs are probably going to be what you get. RSUs, just so you know, are like they're a promise for future equity or cash equivalent at a future date. So they're fine. I mean, at that point it doesn't really matter because the cap table is so like built out and you're not having a huge percent that it's helpful to have. But again, I go back to like early stage, maybe again, always want to have more cash than stock, but I would say later stage, I think it's even more important just to go for like cash over stock, unless you know the company is going to IPO soon, because you can always get more stock. It's harder to negotiate for more cash and salary later, I would say.
Yeah, for sure. That's the tricky part because we get clients who are applying to startups, but a startup can give you a lot more equity than cash because, they're early stage. They don't have enough cash. So I get your point, but at the end of the day, the startup might just not have enough cash versus they might give you a lot more equity.
Yeah, I mean, you're gonna have to take some equity, and you're probably not gonna get an awesome salary in an early stage company and take more equity. But just like if they're like, hey, we can give you 150,000 and like 0.2% stock, or we can give you 100,000 and like 0.5% stock, like I would jump to the 150 point. I mean, that's a terrible example, but that's a good,
We get it.
Yeah.
Yes.
Sorry, what is the distinction between RSA and RSU?
Oh, yeah. So you can think of it like in tiers of how they operate. Top is RSAs are the simplest. It's just stock. Like if I give you 1 million restricted stock awards, that's 1 million shares of stock. Let's just say they're a penny each, so you pay, I don't know, it was like $10,000, no, $10,000, something like that, whatever. That's how much it costs. That's a bad example too, because you never get that much. That's just straight stock. That's like
So you're just given it. Like
you're
once
just given
you
stock.
get an RSA, it is now yours. You own the stock.
You have to pay for it. Yeah, subject to vesting. Typically, like if you do the 4-year, 1-year cliff vesting, like you buy it all now. You file the 83B. Well, I'm not going to get into that. Your lawyer or the company's lawyer will definitely tell you to do it.
Yeah.
For reasons we can talk about another time because it's not very fun.
Yeah.
And then if you leave after like a month, the company just repurchases all the stock you bought at the price you paid. So, basically it just goes back to the company. So you're still subject to vesting.
So ultimately, the price you paid will be reimbursed by the company?
Yeah, it'll be the repurchase price.
Okay. So then how does that differ then from stock options or individual stock? Yeah,
RSUs.
ISOs.
So yeah, when it comes to stock options, it's just giving you the right to buy stock at a certain strike price or exercise price, but you don't own any stock until you exercise. So options are kind of, I'll say they're useless, but like they don't really do
Well,
much.
how is that different from an RSA? Because an RSA, you are also being told if you buy it at this price, that's probably heavily discounted, then you will own it. And then for an option is you have the right to buy it at this price, and when you do, and that's probably discounted as well. I'm trying to like.
You already get the RSA, right? And
So let's go back to the example of the RSA. I give you 1 million shares subject to the RSA or whatever.
Mhm.
I buy it. I now own the stock. I basically like exercised my option for all the shares now.
Okay.
Now I own them. And if you do the 83B, you don't recognize any income on them. And then if you ever sell them in the future, which, they're subject, whatever, to not repurchase rights, then you get long-term capital gains. ISOs are not as great because, again, typically the way they work, if you don't have early exercise, is I have 1 million options and it's like 1-year cliff. So I'll get 250 after 1 year. I get the option now, but I can't do anything with it. So after 1 year, I can exercise 250,000 of them, right? If I want to. But by then, the fair market value's probably gone up. I still have to pay for it. I don't own the stock until I actually pay the price.
Mm-hmm.
And the kind of silly thing to me for options is like you're basically making an agreement to in the future buy stock that is probably not going to be worth anything. So you have to pay cash later. I mean, it's just kind of like delaying what RSAs give you up front.
I see.
Yeah. And there's tax benefits to incentive stock options. Like you don't have to recognize gains on the exercise of incentive stock options, although you do have to do it for the alternative minimum tax. Let's not get into like the details. It's
Got
fine.
it. But basically, RSA is you get the stock now. You do buy
Like
it.
founder stock.
Yeah, and you get it now. The company will also repurchase it back shortly after,
What's
or
the
the
repurchase? The vesting is the repurchase right?
I see, I
So-
see. Okay. And then for options is it's basically you have the opportunity to buy it later at a either predetermined time or at a predetermined type
Oh,
of
just at a predetermined price. Yeah.
predetermined price.
Like
Okay. Because I
after it's
remember in
vested.
some of my past comp packages have included options, but I was only given it basically defined when I can exercise it, and it was under a
Oh,
specific liquidation event. So if we go through another fundraising round, if the company is acquired, if the company decides, hey, we just want to give an opportunity for employees to exercise, so it was only at specific times or types of events for the
yeah, that's kind of
options.
goofy. I mean, you could do that. I don't know. That's like defeats the purpose of the option. It's it's the whole. I mean, it's not really an option then. It's like an option with caveats or
Right.
something.
A
Yeah.
narrower option.
Limited option.
Yeah.
So
Okay, let's move on from this very technical question.
sorry.
What are your thoughts on the new H-1B visa program and, anything to think about there? The companies paying the 100K and all that, like any
I mean, it's
creative.
just a hot mess. Like I don't know what else to say. Like it's such a joke. I'm not even getting political, but like anyone who thinks that decision made any sense, there was no time to plan for companies. It was such an increase in costs. I have a hard time believing it's actually going to survive court battles over time. And I'm not trying to be political. If it wasn't the current Supreme Court and it was like a more regular, like moderate or even like center right Supreme Court, not like a really far. I mean, I just read an article today about how I was listening to the argument today for the Voting Rights Act. Looks like they're going to throw that out. So any other Supreme Court, I'd be like, this isn't going to survive because taxes are clearly Congress's mandate, and this is effectively a tax. Like an additional cost. Like gives the president the right to let people in or out of the country, but doesn't give the president the right to do that. So anyway, I don't know. I mean, it's really bad. If you were trying to get an H-1B and your company doesn't have $100,000 to spend, I wouldn't count on it at this point because that's it's a lot. Didn't it used to be like $1,000 or something like that? It was way cheaper,
Yeah.
10,000 maybe at most. So
Yeah.
So if I'm a job seeker
You need donation.
and I need an H-1B, is there anything that I could be thinking about?
Yeah, can we
or-
pay it as the job seeker? I mean, not that.
Well,
Or can you pay half of it? Is it allowed? I
I
don't
mean, I
know.
guess you could, but like, it depends on how much you're getting paid. And if you're getting paid that much, I would just make your company pay it.
Yeah.
Yeah.
and
I don't know.
and it's not retroactive, right? So if you are already on an H-1B,
Yeah, you're good. I think
You're
it's only
good.
after like September 20th or something like that. It's 21st.
is there
Whatever it is.
what about, does that need to get renewed? And at renewal, then the company needs
So
to
renewals aren't affected, extensions aren't affected. It's just new applications. So
net
anyone who
new
doesn't have an
application.
H-1B now
Okay.
and needs one is going to be in trouble.
Yeah.
They just have much fewer opportunities.
Yeah. This makes me
Potentially.
very sad as an international person. I actually didn't even, I don't know if people, well, Alex Daniels, I don't know if you knew this. So because I had a STEM degree in undergrad, I got the OPT extension. So I could work in the US for 3 years rather than the 1 year that is usually allowed for internationals. But during those 3 years, you apply for H-1B so you can work for another 3 and another 3. I didn't get the H-1B lottery. They say it's a lottery. I think it actually is. And so luckily I got into grad school, so that helped with me staying in the country. But I would have been deported back in 2015 or 2016.
Well, you know what? You're taking American jobs, so you don't need
An
your
American
calendar.
man. I am just stealing
Yeah.
American things left and right.
It's just, it's the worst.
Hey,
And now
the
she
country's
is
so much worse
American.
off.
Now
Yeah.
Gerta is American, so it looks like the tables have
Yeah,
I
turned.
don't know
well,
if you know this,
we-
but like everyone who came to this country before 2025 was a native, and they've always been here. Like, yeah. So,
Yeah.
just gotta read the right history books, guys.
Yeah.
Well, I just want to say now that we have our own business, we're creating jobs. So
Yes.
I'm giving
Yeah.
back. I'm
Yeah.
giving back to the
You're
country.
helping people. You're empowering people in their jobs. So,
Yeah.
That-
They're gonna
that
make more
too.
money from the
but
company.
yeah, I would
Yeah.
also just caution people like the H-1B 100,000. That's not like set in stone yet. Like, there's a good chance the court's gonna freeze it.
Oh,
Or
okay.
overdo it, or Congress. Not this Congress. I'm not even trying to be political, but they don't
Yeah,
do
yeah.
anything. But in a couple years, if Democrats take control or something. Who knows? I could see it being reversed because it's just such on a whim. Like, we're not an autocracy. There's so many balances and checks on this stuff because it was also terribly rolled out. Like, it literally just came out overnight. It went up. It cost like 20, 30%, 30x in one day. That's all. No one had time to prepare.
So I think the takeaway here is there really isn't that much that a job seeker who requires an H-1B, not much they can do. They probably just have fewer opportunities because there will be fewer companies now that are willing to do that. But if you already were on an H-1B, you are good because it's not retroactive. And even if you're on an H-1B and that needs to be renewed, if you were on one before this order or law, whatever, you're still okay. Like, renewals aren't impacted. It's just net new applications, right?
Yeah, it's like new petitions, basically.
Yeah.
Got it.
And it's not a law, but just be clear. Just
Okay, it's not the law yet.
Yeah,
okay.
Yeah, that's good. It's just the guy ranting into the wind about stuff.
So last question, and hopefully this is helpful for you too. When do you recommend people contact a lawyer to review their employment agreement? Is it necessarily when they're senior? Like, do all executives need to get an employment lawyer? Or, like, in general, when should they contact a lawyer? And also, when can they work with you?
Yeah, I would say, to each their own. I'm biased. I think having a lawyer involved, even if it's not me, is really valuable just because you have someone who's seen a lot of this and like understands the legal terms of what you're getting into. I'd say once you get the offer letter and the CIIA, which is the Confidential Information Invention Assignment, like those side agreements that might not be in the offer letter, that's worth reaching out to a lawyer, at least getting like a quote up front of like how much would it cost to review. And it is kind of worth it because I would say if you're making more than like $100,000-$200,000 and a lawyer is going to cost you a few hundred to a few $1,000s, that's like a good investment to make sure you're not taking on a job that's going to hamstring you or like has all kinds of caveats and carve outs and things you never thought about.
And that's usually like, is it true that it's mostly like startups that we need to worry about? Because maybe like Google is so standardized in their offer letters, you probably don't need a lawyer to review those letters.
I don't know. I'm giving the lawyer answer. It really depends. I would say like a startup, you have flexibility for sure, but you also have it with a Google because they have a lot more resources and stuff and accommodations and HR systems and things. So they might be more willing to negotiate. So, it's also tough too, because like you said, it's an employer market right now. So it's not.
Awesome. Well, it was so great chatting with you.
Thank you so
we'll
much.
Wrap it up here.
Yeah, thank you so much for spending this last hour and just knowledge dumping the legal information.
Yeah, sorry if I was ranting there. Yeah, there's a lot here, and but
Awesome. Thank you,
I hope I
Alex.
helped someone.
Yeah, and so if anyone wants to, we'll include links to Alex's website and your LinkedIn.
Decrypted Law.
Yeah, decryptedlaw.com.
.com?
Or .ai? .io?
.com.
.com. .com. Okay.
Probably .ai thing.
.web3.
Yeah.
No, we're joking. We're joking.
But we will include all the links to the show notes if you ever want to talk to Alex and reach out to him, get in touch with him. But Alex Daniels, thank you so much for spending this last hour. I know we covered so many questions that we often get, so I know this will be super helpful for our audience.
Yeah, hopefully.
Okay.
Yeah, thanks for having me, guys.
Yeah.
And have a good day. Enjoy your lives up in San Francisco.
You too.
We'll stop recording now.
Yeah.
Okay.